Hi, everybody. It's Diane Neto living in Barrie. And today I am going to talk about joint tenancy versus tenants in common. Now you have to understand, because I have a deal right in the middle where we're having a problem because one of the owners passed. They thought it was joint tenancy, which you could just sell the property. And now the land registry is saying it's tenants in common. Probate would have to be done. You just can't sell the property. There's a lot of different rules and different ways you can do it based on what your needs are. So I'm going to share the screen and explain joint tenancy versus tenants in common and why this is so important. Now, when you go to sign the paper with a lawyer, he should explain this to you anyway, but not everybody comes out of it understanding what they're doing, to tell you the truth. So I can explain the difference here. Joint tenancy is when two or more people purchase a property together with equal interest in the property and equal rights. This is referred to as joint tenancy. Perhaps the most common form of joint tenancy ownership is that of a married couple. In order to be considered joint tenancy, 4 conditions must be met. They must obtain the property at the same time. They must have equal property interest by each person. Must acquire the title deed from the same document. Equal rights of ownership must be exercised by all tenants. They're calling it tenant, but it's homeowner. So what they're basically saying is that when you buy the property, you can put joint tenancy, you both own 50% of the property. And when that happens and both names are on title, the 50% of the surviving person, if one person passes, automatically gets the whole 100% of the house. Okay? So in joint tenancy, when you hold title in joint tenancy, if one of the co-owners dies, the ownership rights automatically transfer to the remaining owner. So if Bob and Cindy are married and Bob dies, Cindy automatically becomes the full owner of the property. There will be no need to go to probate, and Cindy will not owe any transfer taxes. If the property were joined in joint tenancy by unmarried persons, the remaining owner or co-owners would also avoid the probate process, although they would need to claim the inherited property as a gift. So it is referred to as right of survivorship. So if one person passes, the person that is still alive has to put an application of survivorship in. And then that automatically transfers that other 50% over to them and they get the whole 100%. Okay. Now this could be between a mother and a daughter. This could be between a son and a father and a daughter. It doesn't matter. It could be your best friend, right? You don't have to be related, but that's what joint tenancy means. Everybody owns an equal amount, and you can't add them later and be joint tenants. It all has to be done at the same time, if you know what I mean. That's what they're saying here. So the disadvantages relates to creditors. So if one of the people owes a debt, a creditor has the power to terminate a joint tenancy if the other co-owners have nothing to do with that debt. So if somebody owned a lot of money and they came after that portion, technically okay, so what it's saying is this: if you're seeking joint tenancy with someone who has bad credit, significant debt, or is prone to liability by profession, you need to be aware of these risks. If you do not wish for your ownership to transfer automatically to the other owners and would instead prefer for it to go to your heirs, joint tenancy is also not a good option for you. Another disadvantage is that if you and the other co-owner cannot reach an agreement on what to do with the property, you would need to file a lawsuit referred to as a partial action or partial action. I'm not a lawyer, people. I did take property law and we did learn about this. So, and it could be costly and time consuming, right? So basically as joint tenants, your portion automatically goes to the other people. But say I'm in an investment property with my one son and I want my portion to go to my other son. In that case, if I wanted that, then it would have to be tenants in common, right? Because tenants in common, as I will explain over here, tenants in common is if multiple people hold title under tenancy in common. This means that each individual can choose to sell their ownership interest rights in the property at any time. So unlike with joint tenancy, a tenants in common agreement allows for multiple owners to own different percentages of the entire property. Although one tenant could potentially own 30%, while other owners own 35% each, this does not mean that certain areas of the property are owned by those holding the larger owner percentage. The entire property is available to each owner, regardless of the percentage, and that is called undivided interest. Additionally, on the occasion of their death, each co-owner may choose who will be the beneficiary of their ownership as part of the estate. So if I own 50% and I want to leave that portion of my estate to somebody, then the other owner would have to either get a mortgage and buy the person out and give it to the estate, or you sell the property and the estate takes half. In which case you would have to probate the will, because the title isn't automatically changing. So the advantage is each owner does not need to have equal shares. So you could have 25% to 75%. This type of joint ownership is ideal for groups of people looking to share property, or married couples who, for whatever reason, do not wish to share their property to transfer automatically to the surviving spouse upon the death. So, and I'm going to give you the example they have. So a lot of people these days, you get married for the second time, right? You're both widows, you get married. You have children, she has children. And now on your death, you want your portion of that property to go to your children. She wants her portion to go to her children because you both invested in it. So that's how you would do tenancy in common for that. The disadvantages: if you do not have a will and hold title via tenancy in common, your share of the property will be distributed according to the probate laws. Under tenancy in common, there is no right of survivorship. If you share ownership through a tenancy in common title, your co-owners can sell their portion without your say, meaning that theoretically owners could find themselves co-owning property with complete strangers, which wouldn't happen, right? So in joint, these are the key differences: equal interest, equal ownership, simultaneous obtaining of the property, and same title document. If one dies, it automatically passes to the other person. And if one owner wishes to terminate, they can sell to the other owners. Okay. Tenancy in common, tenants may own a different percentage of the property, and owners may convey property to anyone upon their death as long as it's written in a will. And any tenant can sell their ownership stake at any reason at any time. So one thing that you have to realize is that you definitely need to think about this ahead of time, and when you buy the property, how you want to do this. Because later, which I'm having the problem right now, there's some big problems. Because someone has passed and now we can't sell the property. Well, we're having problems, there's issues, and you really have to think about how you want to do this and set it out beforehand right away so that you don't have these problems, because it can be a nightmare for the survivor later. If you like my comment, hit the like, subscribe, drop me a comment if you have anything you would like me to talk about.